So imagine this scenario. You've worked your entire life. You have paid the mortgage every single month for 30 years.
Right.
You've finally paid off the family home. It's your castle, your biggest asset. It's the legacy you want to leave behind. But then you pass away. And instead of that house going straight to your spouse or your kids, it gets stuck.
It's completely frozen.
Exactly. It enters this terrible legal limbo. The government, lawyers, the court system, they essentially hold the keys for a year. Your family can't sell it. They can't transfer it. They can't even refinance it to pay for your funeral. They are essentially bleeding money in fees while
they're just trying to grieve. Yeah.
Right.
It is a total nightmare scenario. But unfortunately, looking at the data, it's one that plays out in courthouses every single day. And I think the worst part about it, it is almost entirely preventable.
Welcome back. Today we are on a mission. We're looking at estate planning, but we are zooming in specifically on the home, the bricks and mortar. And we've got a really fascinating comparison today because we are looking at two states with very different rule books, Tennessee and Texas.
That's right. And while we are comparing those two states, because, the contrast is just so perfect for understanding how this law actually works, the principles we're going to uncover here, they really apply to anyone who owns property and wants to make sure it actually goes to the people they love.
Exactly. And look, I know estate planning sounds like something only the super rich do, or it sounds like a boring stack of paperwork that you just put off until you're 80. But looking at these sources you brought in, this isn't really about paperwork.
No, absolutely not. I think we need to reframe this right out of the gate. This isn't about legal technicalities. It is about family protection.
Family protection. I like that.
Right, because that's the core theme here. If you don't have a plan, the state has one for you. And I can almost guarantee that the state's plan does not match what you actually want.
So let's unpack this. We're going to look at the probate monster, why we want to avoid it. Then we're going to do a showdown between Tennessee and Texas to see what tools they offer. And finally, we'll look at the gold standard solution that works pretty much everywhere. But first, we have to define the enemy.
Yeah.
What actually is probate?
Right. So in plain English, probate is essentially a lawsuit you file against yourself after you die.
That is, wow, that is a terrifying way to put it. A lawsuit against yourself.
Effectively, yeah. It's a court-supervised process. Its entire job is to validate a will if you have one, pay off your debts, and then distribute whatever is left to your heirs.
I mean, it sounds very administrative, very orderly.
It sounds orderly, sure.
It sounds incredibly boring, actually, which usually means it's safe. But the sources suggest otherwise.
It is anything but safe for your time and your money. Just think about it. You are asking a judge who has hundreds of other cases and knows absolutely nothing about your family to sign off on every single step of transferring your life's work. In Tennessee, the sources tell us this process typically takes 6 to 12 months.
6 to 12 months. So the house is just sitting there.
Effectively, yes. I mean, the family can usually live in it, but they lack marketable title. They can't sell it easily. If there's a financial crisis, say the main breadwinner died and the surviving spouse needs cash, they can't just go list the house on Zillow. They are stuck waiting for a judge to say, okay.
And I assume this isn't some free public service provided by the state.
Oh, definitely not. You've got court filing fees, you have bond premiums, you almost certainly need an attorney, and they bill by the hour, or in some states, they take a percentage of the total estate value.
So we're not talking a few $100.
No, we are talking thousands, sometimes tens of thousands of dollars, completely drained from the inheritance.
Just to get permission to own what you already thought you owned.
Precisely. And then there is the privacy aspect. This is the one that really shocks people. Probate is a public process.
Meaning what, exactly?
Meaning anyone can go down to the courthouse or just look online and pull the records. They can see what you owned, who you owed money to, and exactly who is getting what.
Wow. So nosy neighbors, scammers, long-lost relatives who smell money, they all get a front row seat.
Exactly. It completely strips away your family's privacy at their absolute most vulnerable moment. There are literally businesses that scrape this probate data just to sell leads to real estate investors who are looking for distressed properties.
That is incredibly predatory. Now, I did see one little loophole in the Tennessee notes, something about a small estate exception.
Yeah, the small estate affidavit. So in Tennessee, if an estate is worth under $50,000, you can file a simpler form after 45 days and skip the full probate circus.
Okay, but we're talking about real estate here.
Yeah.
I don't know about you, but I haven't seen a decent family home for $50,000 since, well, maybe never.
Precisely. That's the catch. This exception rarely applies to homeowners. Even a very modest home is going to push the estate value way over that $50,000 limit. So, for the vast majority of our listeners, if you own a home, that loophole is closed. You are heading for full probate unless you plan ahead.
Okay, so probate is slow, it's expensive, and it's public. We definitely want to avoid it. Now, this brings us to the biggest myth in the stack of sources. And I have to admit, I completely believe this one too. The "we're married" myth.
Oh, yeah. This is the one that really gets people in trouble. It's the complacency of, I'm good, we're good.
Right, the assumption is simple. I'm married, my spouse and I live in the house together. If I die, obviously they get the house. It's automatic.
It feels intuitive, doesn't it? You share a life, so you share that asset, but legally that is not always true. Joint ownership alone does not guarantee the home skips probate.
That is terrifying. Break that down for us.
Sure.
Why not?
It all comes down to the specific language on the deed itself. You can own a house jointly as tenants in common. If you're tenants in common, you each own a separate 50% share. If you die, your 50% doesn't just slide over to your spouse, it freezes.
It freezes.
It becomes part of your estate. It has to go through probate to be legally transferred to them. And here is where it gets really messy. If you have a blended family, say, children from a previous marriage, and the deed isn't set up right, those children could technically claim a share of that house.
Wait, really?
Yes, your spouse could end up owning the house with your estranged stepkids.
That sounds like a recipe for an absolute holiday dinner disaster.
It's a recipe for a forced sale, honestly. The stepkids might want their cash right now, forcing the surviving spouse to sell the home just to pay them off.
But wait, I can hear the listeners screaming at their speakers right now. But I have a will. I wrote a will saying my spouse gets the house.
And this is the second biggest trap. We really need to clear this up right now. A will does not avoid probate.
Say that again for the people in the back, because that is a huge misconception.
A will does not keep you out of court. In fact, a will is basically a letter addressed to the probate court.
To the court.
Right. It's a set of instructions for the judge. It tells the judge, please give my house to my wife. But the judge still has to read it, validate it, stamp it, and oversee the actual transfer.
So the will is just the script for the play, but you still have to rent the theater and hire the actors.
That is a perfect analogy. The will is essential, don't get me wrong. You absolutely need it to name guardians for your kids and pick your executors. But if you're relying on a will to transfer your house smoothly and privately, you're going to be very disappointed. Titled assets like a house that are just in your name or don't have that specific survivorship language, they must go through the system.
Okay, I think we've successfully scared everyone. We know the problem. Now let's talk solutions. This is where we get into the battle of the states. We have Tennessee and Texas. Both have very unique ways to handle this. Let's start with Tennessee.
All right, let's look at the volunteer state. If you are a married couple in Tennessee, you have a very powerful tool available to you called tenancy by the entirety.
Tenancy by the entirety. It sounds very medieval.
It does, doesn't it? It goes back to Old English common law.
Yeah.
But it's fantastic. It's a special form of ownership reserved strictly for married couples. If your deed says as tenants by the entirety, it creates a legal fiction where you aren't two people owning 50% each. You are one single unit owning 100%.
So what happens when one spouse dies?
Because the unit still exists in the surviving spouse, the property transfers instantly. No probate, no court, no waiting. It's automatic by operation of law.
That sounds like exactly what we want. So if you're in Tennessee, go check your deed right now.
Yes. Look for that exact phrase. If it's not there, you might just be tenants in common, which is the dangerous one we just talked about. You need to see tenancy by the entirety or at least joint tenants with right of survivorship.
Now, is there a downside in Tennessee?
Well, there is a limitation. Tennessee is a bit old-fashioned in one regard. Some states allow you to put a transfer on death designation on your house. It's kind of like naming a beneficiary on your bank account.
Right, like when I die, pay this to my son. Super simple.
Exactly. But Tennessee statutes generally do not allow transfer on death deeds for real estate. You can do it for your bank account, you can do it for stocks, but not the actual house.
So if you aren't married, say you're a widow or single, and you want to leave the house to your kids directly without going through probate, you have fewer simple options in Tennessee.
You're kind of stuck. The tenancy by the entirety only works for spouses. If you want to skip probate for the kids, you can't just slap a beneficiary sticker on the deed. You need a more robust tool, which we will get to.
Got it. So Tennessee is great for spouses if you have the right magic words, but trickier for passing it to the next generation without a trust. Now let's travel south to Texas. How do they handle it?
Texas offers a very different toolkit. For married couples, they use something called community property with right of survivorship.
That sounds pretty core to the Tennessee one.
It achieves the same goal, but the mechanism is a bit different. Texas is a community property state. Usually, community property doesn't automatically have survivorship rights. You have to actively create them. It requires a signed agreement. You have to actually put it in writing and file it. But once you do, the home passes automatically to the survivor.
But Texas has an ace up its sleeve, doesn't it?
Yeah.
The source mentioned something called a TODD.
Yes, the transfer on death deed, or TODD. This is a huge advantage for Texans that Tennesseans just don't have.
How does that work?
It is exactly what it sounds like. It's a deed you fill out and record with the county right now while you're still alive. You name a beneficiary, say your spouse, or if you're single, your children.
And what happens when you die?
The moment you pass away, ownership transfers to that person. No probate, no court interaction required at all. It just happens. It's almost like magic.
Okay, but what if I change my mind? What if I name my son, but then he, I don't know, runs off to join the circus, or worse, starts rooting for the wrong football team, and I decide I want to leave it to my daughter instead?
That is the beauty of it. You retain full control while you are alive. The beneficiary has absolutely zero rights to your house until you die. You can sell the house, mortgage it, or revoke the deed and write a brand new one anytime you want. The beneficiary doesn't even need to sign it or know about it.
That seems incredibly flexible. Why doesn't every state have this?
It's purely a legislative choice. Real estate law is very state-specific. Texas has embraced it as a way to clear up court dockets. Tennessee has resisted it, likely to preserve the more traditional title transfer methods.
So comparing the two, Tennessee relies heavily on how you hold the title initially, that tenancy by the entirety, whereas Texas gives you a specific instrument, the TOD, to designate the future path of the home.
Correct. But there is a catch with the TOD in Texas.
There's always a catch, isn't there?
Always. It comes down to title companies. Sometimes, even with a perfectly valid TODD, title insurance companies can be a little skittish about insuring the property immediately after death. They worry about hidden creditor claims or family disputes. There's often a 2-year waiting period where they might hesitate to issue a full policy. So while it avoids probate, it's not always instant cash if the heirs want to sell immediately.
That is a really crucial nuance. So it transfers the ownership, but selling it might still have a hiccup.
Exactly. It's not a silver bullet, but it is vastly better than going through probate.
Okay, so we have the Tennessee method and the Texas method. They both have pros and cons. But what if your situation is complicated? What if you have that blended family we talked about? Or what if you want to control exactly when the kids get the money, like maybe not giving an 18-year-old a free house? The sources point to a universal solution.
Yes. The level up, the revocable living trust.
We hear about trusts all the time. It feels like something for the super rich, or something you see in movies where the spoiled kid gets a trust fund. But explain it simply. How does a trust solve the house problem in both states?
The easiest way is to think of a trust as a private box, a safe. While you're alive, you hold the box. You are the trustee. You put your house inside the box.
And this is the step people miss, right? Putting the house actually in the box.
Oh, it's a crucial step. It's called funding the trust. We see this all the time. People pay a lawyer $3,000 to write a beautiful trust document, but they never actually record a new deed moving the house from John Smith to the John Smith Trust. If you don't do that, the trust is just an expensive doorstop. The house is still outside the box.
Okay, so let's assume I did it right. The house is in the box. I'm holding the box. I can sell the house, paint the house, burn the house down if I want. I have total control.
Total control. Nothing changes about your taxes, your homestead exemption, or how you live. But here is the magic trick. When you die, you don't own the house. The box owns the house, and the box doesn't die.
So there's nothing for the probate court to do.
Exactly. The probate court handles assets of the deceased. But since the trust still lives on, there's no transfer to oversee. You've already appointed a successor trustee, maybe your spouse or an adult child, to take over holding the box. They step in immediately. No judges, no 6-month wait, no public records.
The privacy factor here seems huge.
It is the ultimate privacy tool. Unlike a will, a trust is a private contract. Nobody knows who got what or how much it was worth. It literally never sees the inside of a courtroom.
And it handles the what-ifs better too, right?
Oh, much better. With a deed or a TOD, you are usually just looking at step 1. If I die, it goes to her. A trust allows for really complex instructions. If I die, it goes to my spouse. If she dies, it goes to the kids, but not until they are 25. And if one of the kids has a gambling problem, their share stays in the trust managed by someone else.
Wow. You can really govern the legacy from the grave, so to speak.
Yeah, it allows you to protect your family from themselves and from outside predators. It works in Tennessee, it works in Texas, it works everywhere.
So, to recap the hierarchy here, level 1, check your deed language. Right of survivorship or tenancy by the entirety. Essential for spouses, but limited. Level 2, use state tools. If you're in Texas, look at that transfer on death deed. It's a great, cheap shortcut. Level 3, the trust. Total privacy, total control, handles complex families.
That is a perfect summary.
But now we have to deal with the hardest part of estate planning. It's not the legal forms, it's not finding a notary public, it's the conversation.
The kitchen table talk.
Yeah. How do you turn to your spouse over cornflakes and say, hey, honey, let's talk about when I die? It feels morbid. It feels like bad luck.
It does, and that emotional barrier is the #1 reason people put this off. They think talking about death somehow invites death. But the sources give us some really great advice here on how to reframe it. Do not make this about legal control.
Right. Nobody wants to hear, I need to control the assets. That sounds so possessive.
Exactly. Frame it as family protection. That is the key phrase.
Family protect.
You say, I want to make sure that if something happens to me, you and the kids aren't stuck dealing with the judge for a year. I want to make sure you have immediate access to the home without paying thousands in fees.
That shifts it from being about death to being about love. It's an act of care.
Precisely. It's about peace of mind. You are removing a burden from their shoulders before it even happens. And honestly, having seen what probate does to grieving families, the fighting, the waiting, the draining of bank accounts, keeping them out of court, is one of the absolute greatest gifts you can give them.
It really is.
Yeah.
You know, we spend so much time fixing up our homes, painting the walls, fixing the roof, mowing the lawn. We obsess over the curb appeal. But if the legal foundation is crumbling, none of that matters.
That's the truth. You can have the most beautiful house on the block, but if the title is a mess, you're leaving your family a headache instead of an asset.
So what is the big takeaway for our listener today?
The takeaway is action. This deep dive is for education, obviously. We aren't your lawyers. But you need to go find one. Whether you are in Tennessee or Texas, find a qualified estate planning attorney.
And specifically, ask them to review your deed.
Yes. Don't just ask for a will. That's the rookie mistake. Ask them, how is my home titled? Does it have right of survivorship? And do I need a trust or a transfer on death deed to keep my family out of court?
Those are the magic questions.
And do it now. The thing about estate planning is that it's always too early until it is suddenly too late. You don't get a warning shot.
That is a very sobering thought.
It is, but it's reality.
So, as we wrap up, I want to leave you with a question to chew on. We talk about the nightmare scenario at the beginning, but let's flip it. Imagine the peace of mind of knowing it's done. If something happened to you tomorrow, ask yourself, would your family be grieving in peace in the comfort of their home? Or would they be grieving in a courtroom, filling out forms for a judge?
It's a choice you make today.
Thanks for diving in with us. Check the show notes. We've listed out those terms like TODD, tenancy by the entirety, and probate, so you can cheat on your homework before you call that lawyer.
Stay curious and stay prepared.
We'll see you on the next time.
Faithful God, the God who knows my beginning, the one who sustains my being, my source, my light, my everything, the King who stooped to stop my doom, who left his throne to enter my gloom.